J. Davitt McAteer has served as the Clinton administration both as Assistant Secretary of Mine Safety and Health and as acting solicitor. He was appointed by the Governor of West Virginia to chair the panel that investigated the causes of the Sago, Aracoma, Alma accidents, and Mr. McAteer is Vice President for sponsored programs at the Wheeling Jesuit University in West Virginia. He graduated from West Virginia University College of Law.
Chairman Miller, Ranking Member McAllen, and members of the committee. My name is Davitt McAteer, and I thank you for this opportunity to present my views about MSHA. From 1994 to 2000, I served as the agency's Assistant Secretary and also served for a time as the Acting Solicitor of Labor. I have been involved in mine safety and health issues since 1968, following the tragic Farmington, West Virginia mine disaster. Following the disasters at Sago and Aracoma Alma, Governor Joe Manchin of West Virginia asked me to lead an investigative panel into the causes of those disasters. In July and November of last year, I produced reports into those disasters, and I submit a copy of those reports for the record today. Following the disasters of 2006, the families of the Sago, Aracoma, Alma, and Kentucky Derby victims, this committee and the American public asked the question, why hasn't the federal government acted to bring about changes in health and safety protections afforded miners? And why aren't new communication systems, seals, rescue chambers, and improved SCSRs been placed in the mines? While the answer is complex, the bottom line is this. Miners still like a wireless, durable phone system. 14,000 alternative seals have not been strengthened, and rescue chambers have still not installed. Those looking beyond the 2006 tragedies are also mystified that MSHA's regulations to protect miners from black lung is nearly 30 years old. Its asbestos standard is 20 times less protective than OSHA's, and its rules on mine rescue teams are seriously outdated. The list of unfulfilled promises to miners goes on, and during this past 6 years, this administration has terminated multiple regulatory undertakings, including important rules on SCSRs, mine rescue teams, and black lung prevention. There is no doubt that an administration's regulatory philosophy plays an important role in whether regulations are issued and in the type of regulations pursued, but that is not the only factor at play. If congressional oversight focuses exclusively on politics, it will miss a tremendous opportunity to address a serious problem that exists beyond the resident of the White House. Before being appointed to MSHA in '94, I was one of the agency's harshest critics. When I started the job, I had high expectations in the form of new protective standards, and during my tenure, we finalized a dozen significant regulations. Some of these had been initiated by my predecessor, and others were commenced and completed during my term. Despite my determination to issue rules and the commitment of MSHA's talented engineers and scientists, I am only modestly satisfied with our regulatory accomplishments. In my case, the fault did not lie with the agency's lack of commitment to miner safety or unwillingness to regulate. MSHA is a small agency within a large federal bureaucracy. Its mission is only one of many within the Department of Labor, and it does not operate in a vacuum. Promulgating workplace safety standards is a process fraught with obstacles. It was a problem when I was at MSHA, and it will be a problem for the next administration. Some of the roadblocks were the administration's own making, and some were created by my fellow lawyers exploiting the regulatory system. When a rule is controversial, and most are, it will take 4 to 6 years to complete. In the worst of cases, the procedural maneuverings obstruct the process, and those rules are never completed. This unfinished business of protecting miners is the result of a broken rulemaking system. Interest groups who have a stake in avoiding or postponing new workplace safety rules have the financial resources to bog the system down. There are numerous examples of this in MSHA's history, but one of the most troubling to me is the mining industry's effort to obstruct MSHA's plan to correct the manner in which miners' exposure to coal dust is measured. One of my highest priorities was attempting to transform MSHA's regulations to eliminate black lung disease once and for all. Our efforts were comprehensive, and one small part included dismantling a dust monitoring scheme put in place by the U.S. Bureau of Mines in 1971. This outdated policy I'm sorry. Under this outdated policy, miners exposed to coal dust are calculated based upon an average of multiple samples. You may have 2 or 3 dusty jobs in a coal mine, and the agency is required to average those miners' exposures with samples collected from less dusty jobs. More times than not, the average will be less than the enforceable limit, meaning the mine operator does not receive an MSHA citation and the inspector cannot compel the mine operator to correct the problem. Beginning in '91, we attempted to change this policy, but an unfavorable decision by the MSHA Review Commission forced us to engage in a formal rulemaking. We sought to officially revoke the sampling average policy and replace it with the safeguard of a single shift dust sample. After a 4-year rulemaking process with multiple public hearings, we issued a joint rule with NIOSH. The mining industry challenged the rule, arguing that we failed to conduct a proper rulemaking. Their challenge was upheld by the Court of Appeals. We were forced to begin another rulemaking to revoke this harmful policy. Regrettably, the rule was not finished before I left, and today the 1971 averaging scheme remains in effect. I describe in my written testimony 3 hazardous situations faced by miners in which practical solutions exist today. Those are the presence or absence of proximity detectors, hardened cabs on bulldozers, and backup cameras on large haulage trucks. These are circumstances that kill miners day in and day out over the years. We have solutions, and because of the nature of the regulatory system, we can't get those solutions to be put in place. I submit that the current regulatory system is broken and we need to find a new approach to protecting miners' health and safety. I would suggest the 4 items for your consideration. First, we need a full public analysis of accident, injuries, illnesses, and near misses. If you would, a national report to Congress on health and safety related to best practices. That is what has been done within an industry, as well as deficiencies in protected miners. These best practices could then become a norm to help establish the duty of care against which an individual's company could be judged. Even absent a specific regulation, mine operators would be on notice that protections exist and are available, and they have a duty to act, whether or not a specific regulation is in place. Second, the establishment of a duty of care responsibility for each mine operator. The duty of care would require a thorough process of hazard identification, risk assessment, and risk control, and would be coupled with the regulatory system, not replacement for the regulatory system. This model has been successfully adopted in several countries, including Australia and Canada. Third, incorporating into mine safety and health into the production of mining equipment, production equipment. This is akin to requiring for the installation of safety equipment on automobiles as part of the automobile manufacturer's responsibility and not the responsibility of the automobile driver. For example, longwall mining machines cost in excess of $50 million and are unparalleled in their ability to mine millions of tons of coal. Yet few, if any, safety and health features are designed into this equipment.
Mr. McAteer, I'm going to have to ask you if you can wrap up.
Sorry, we'll wrap it up. Fourth is the permitting a quasi-regulatory requirement agreed upon by all parties as part of the duty of care. And finally, for Congress to follow the model established in the landmark 1969 Coal Act to instruct the industry directly on what is expected of them. With these changes, I believe we could improve the protections for miners and also avoid the Sagos, Aracoma, and Kentucky Derby type accidents. Thank you, sir.